Good evening, everyone. Kong Hei Fat Choi, a very happy year of the horse to all of you, and a very warm welcome to the Rowdget Young public lecture here at HKU Law. This lecture has a long and distinguished history. Since its inception in 1994, the Rowdget Young Lecture has brought to us a remarkable succession of judges and scholars, from Sir Robin Cook in his early years through leading comparative and commercial lawyers such as Professors Donald Clark and John Armour, to most recently in 2024, Professor Odudu on competition law. Over more than 3 decades, the lecture has grown into a signature event of our faculty, shaping debates in Hong Kong and across the common law world. But none of this would have been possible without the generosity and support of the Young family. And we're especially honored that Mr. Rowdget Young Jr. is with us this evening. On behalf of the faculty, I would like to express our sincere thanks to you and to the Young family for your long-standing commitment to Hong Kong U and to the legal profession in Hong Kong. Your support has enriched generations of students, scholars, and practitioners. And the continuing vitality of this lecture is itself a testament to that commitment. So thank you very much. I would also like to extend a special welcome to members of the Judiciary, including judges on the Court of Final Appeal, Court of Appeal, and Court of First Instance, as well as to our distinguished guests and alumni who have joined us this evening. Thank you very much for your time, and thank you for your continued engagement with the faculty. And let me also acknowledge those who are not physically present in this room, but are following the proceedings by live streaming in our overflow room on the 8th floor. You're very much part of this evening, and we're very delighted to have you with us. And it is now my great honor to introduce our speaker, Professor Charles Mitchell, KC. Professor Mitchell has been a professor of law at UCL since 2010. He is one of the leading figures, if not the leading figure in my view, in the law of trust, fiduciary obligations, and restitution. His contribution to legal scholarship has been recognized in many ways, amongst them his election as a fellow of the British Academy and his appointment as an honorary KC. But to me, most importantly, he is a longtime friend of this faculty, having visited us on several occasions over the years. And this year's Rowdget Young public lecture is entitled One Term, Two Concepts, Breach of Fiduciary Duty in the UK Supreme Court. So in 2025, the UK Supreme Court revisited some of the most basic questions about fiduciary duties and monetary remedies in several major appeals. A central theme of tonight's lecture is that the courts have, for too long, deployed a single label of fiduciary duty to capture two quite different ideas. First, the idea of a duty of due administration, and secondly, the idea of a duty of undivided loyalty. So how should we distinguish between these two concepts if we're to make sense of when fiduciary duties are owed and how monetary remedies for breach should be assessed? So this is the question that lies at the heart of this evening's lecture. So please join me in welcoming Professor Charles Mitchell, KC, to enlighten us on this question.
Thank you, Rebecca, for the kind introduction, and thank you, everybody, for being here. So, trying again? Right. So I've said thank you. I will cut into the lecture. So this lecture was prompted by 4 decisions of the United Kingdom Supreme Court last calendar year, in all of which the court revisited different aspects of the law governing fiduciaries This is an area which is characterized by judicial statements that the law is well settled and understood. And I've sort of felt some skepticism about that since there were 4 trips to the Supreme Court in a single year. It suggested to me they couldn't be that well understood. And one of the themes of my talk is that one of the aids to trying to kind of disentangle what's really a complicated set of thank you. Yeah, I know. A complicated set of rules is to try and distinguish between different concepts, and ideally, possibly try and get into the habit of calling them by different names. So, my talk I'm going to divide into 3 parts. In the first half, I'm going to cover some general principles and try and describe them in the terms which I've just described. And then in the second part, I will look at 2 of the Supreme Court decisions, explain what they were about, and offer some critical comments. So, running through some ideas about fiduciaries with which I expect everybody will be familiar. Parties who are in a particular kind of relationships, which are called fiduciary relationships, are subjected to a particular set of rules which have evolved out of equity cases over many years. Some of these are status-based, i.e., people who are in these relationships are known to be fiduciaries because there are authorities which tell us that people who are in those kinds of relationship always are fiduciaries listed out there. But there are also some ad hoc fact-based ones where the courts will say that a relationship of that kind exists, where certain factual features are present, essentially an assumption of responsibility in relation to the management of property or affairs of another, where the other has an expectation that he or she will act with loyalty in connection with those responsibilities. Now, in Bristol and West Building Society, Mothieu, decision of the English Court of Appeal, Lord Justice Millett, as he then was, insisted that the idea that the term fiduciary duty should be confined to a particular set of duties which are peculiar to fiduciaries, meaning that people who are in those relationships I've just referred to, and breach of which attracts legal consequences which aren't like those consequent on the breach of other duties. And that's a kind of well-known statement. And courts quite often refer back to it. But in spite of their warning, courts and lawyers continue to use the term to describe different duties. Not all of them are owed uniquely by parties in a fiduciary relationship. And I think we need to distinguish them, preferably give them different labels in order to get a better understanding of their content, what happens if you breach them, what happens when third parties participate in their breaches. So list out 3. Some fiduciaries have got powers over property. Not all fiduciaries do, but some do. And when they do, and that's typical, for example, of company directors and of trustees, then it's likely that they may owe at least 3 duties, which were listed in a case in the United Kingdom Supreme Court called AIB, which I've listed out there. The first one is a custodial stewardship duty, duty to preserve the assets of the trust, except insofar as the terms of the trust permit. I'm going to refer to that in my talk as a duty of due administration. The second one is a management stewardship duty, duty to manage the property with proper care. And the third is a duty of undivided loyalty, prohibiting the trustee from prioritizing his own interests over those of his principal, but also forbidding fiduciaries from serving more than one principal at a time. I'm going to refer to that third duty in my lecture as a loyalty duty. So the first one, the duty of due administration, a couple of authorities here which tell us in Yu Yang, the High Court of Australia, perhaps the most important duty of a trustee is to obey the terms of the trust. So if you're a trustee, you're holding property subject to instructions which have been set out for you in the trust deed by the settlor. And you can't validly use your powers over the property in ways which are inconsistent with the terms. The same rule applies to company directors, as stated in an English case called Reed Duck Quarry. If they misapply company property, then they'll be under liability to make good the lost company property. In this context, misapplication means disposition of the company's property, which by virtue of any provision of the company's constitution or statutory provision or any rule of general law, the company or the board is forbidden or incompetent or unauthorized to make. Okay, the second duty is the skill and care duty. In Matthew, Lord Justice Millett insisted that although many fiduciaries do owe a duty to act with skill and care, that is not a fiduciary duty. It's a mistake to call it that, and it's a cause of confusion. That's sort of orthodoxy in the English jurisdiction anyway. Affirmed by the House of Lords in Hilton and Barker, Booth and Eastwood. The third one, the loyalty duty, very often is the one which most commonly people have in mind when they refer to fiduciary duties. A summary of the rules are pretty well known by in a case called FHR, and Lord Newberger there told us that an agent has a fiduciary duty to his principal because he's undertaken to act on his behalf in circumstances giving rise to a relationship of trust and confidence. Therefore, he must not make a profit out of his position or place himself in a position where there's a conflict. And then he says, as Lord Upjohn pointed out in Phipps and Boardman, the formal proposition is part of the latter wider rule. So it's interesting, in FHR, he's suggesting that the no profits rule is a kind of a part of the no conflicts rule, a kind of proposition which in Riccardi, a case I'm going to get to shortly, Lord Briggs flatly denied. So there's some inconsistency in the Supreme Court justice's views on that particular point. And thirdly, there he says, this loyalty duty isn't just about avoiding conflicts of interest between your own interest and your principal's interest. You must also not have two principals with conflicting interests. Now, third parties in Novashit, the Court of Appeal said that there were two different ways in which somebody who's not a fiduciary may nevertheless become mixed up in a breach of a fiduciary duty by someone else. They might either be a knowing recipient of trust property or its proceeds, or they might be a dishonest accessory to the breach of duty. A person may be liable under both heads, depending on the facts of a particular case, but neither a knowing recipient or a dishonest assistant has ever promised, either expressly or inferentially, to subordinate his own interests to those of the beneficiary. Neither is a fiduciary. So if you receive property which has been given to you by a fiduciary in breach of duty, you may incur a liability, but it's not because you yourself are a fiduciary. There's been no voluntary assumption of responsibility by you. And the same is true of dishonest assistance. So the question arises in connection with liability for knowing receipt. We're told by Lord Justice Hoffman in a case called El Ajou in the Court of Appeal that to make out a claiming knowing receipt, there must have been a disposal of assets in breach of fiduciary duty. He's using this term breach of fiduciary duty, but I think it's really most likely that what he has in mind there is the duty of due administration. What he's talking about is a case where a defendant, for example, receives property from a trustee, which is transferred to the defendant in a transaction which is contrary to the terms of the trust. So the problem there isn't that the trustee's been disloyal. The problem is that the trustee's acting beyond the scope of his authority as defined by the terms of the trustee. And I think that that's true of well, I think it's true of all knowing receipt cases. In fact, and Professor Lucina Ho and I have just written an article in which we try and argue for this point, but there are unfortunately one or two cases against us, which I've listed there at the bottom, where the courts have said the primary wrong is breach of the loyalty duty, not the duty to administration. Now, a fiduciary who makes a gain by breaching his loyalty duty may hold the property which he makes out of his breach on a constructive trust. That's the kind of ratio of lots of cases, Phipps and Boardman or FHR. As trustee of that constructive trust, the fiduciary may owe duty to administration, which he may breach by transferring the property to a knowing recipient. And that was what the first instance Australian judge held in a case called Queensland Mines and Hudson, which subsequently made it up to the Privy Council, where the court said that there'd been no breach of loyalty duty in the first place, so there'd been no constructive trust. But the point to notice there is that you may, as a fiduciary, breach your duty of loyalty, make a profit, then you're holding the profit of that profit on constructive trust, and then a duty of due administration kicks in, because you can't validly then use the money which you're holding on constructive trust for your own purposes. You owe a duty to hand it over to your principal. You breach that duty if you then give it to a third party instead. It's also possible to dishonestly assist either in a breach of duty of due administration or a breach of a loyalty duty. And the loyalty duty cases are listed. A couple of them have put there: Belmont Finance, Group 7. Sorry, that's duty of due administration. And in this case called Stevens and Hotel Portfolio 2, which I'll come on to in a moment, the Supreme Court says it's also possible to assist in a breach of duty of due administration by a trustee of a constructive trust of unauthorized fiduciary gains. And in Rowdget, we're told that you can be liable for assisting a breach of loyalty duty. So dishonest assistance, there's authority which clearly establishes that it's possible to incur liability as an accessory for assisting in both of the breaches of both of these duties. Now, moving on to the money awards which can be made against these various people. If you're a fiduciary, you're holding property subject to limits on your powers to dispose of it. You breach your duty of due administration if you pay the money away in a transaction which isn't consistent with those limits. And there's lots of cases, mostly to do with trustees, which tell us that in those circumstances, you will incur a compensatory liability to reconstitute the fund. Now, that liability historically has always been understood to be assessed by reference to principles which were quite different from the principles which govern assessment of liability, a common law for breach of contract, for example, or in tort. The extent to which that remains the case is controversial, owing to the House of Lords decision in Target Holdings, which was subsequently affirmed by the Supreme Court in AIB, which I want to kind of bring the rules there back closer to the kind of common law ideas. But in other jurisdictions, such as Australia, the courts are holding out for the old equitable way of doing things, as in Yu Yang, for example. the money awards that you can be made against knowing recipients are assessed in the same way as money awards would be made in cases where an express trustee had paid money away in a breach of trust. And the rules on that go back a long way, but I guess they're sourced in Barnes and Addy, where Lord Selborne, the Lord Chancellor, said the responsibility of a trustee may no doubt be extended in equity to others who are not properly trustees if they have participated in the fraudulent conduct of the trustee. That needs to be understood in the terms which were expressed in a Privy Council decision called DD Growth, where what that's saying is you're a knowing recipient of funds which have been paid to you by somebody who's acting in breach of trust. Your liability is essentially a custodial liability comparable to that of an express trustee imposed on you because you have sufficient knowledge to affect your conscience. So you've not agreed to be a trustee, but the court will assess your liability as though you had, as a response to the wrong you've committed by knowingly receiving the property. Money awards against dishonest assistance. There's a rather complicated set of rules here. If you dishonestly assist either in a breach of duty of due administration or in a breach of the loyalty duty, if you make a profit for yourself by doing that, then you are liable to pay the value of your profit. But you're not jointly liable with the fiduciary for gains which the fiduciary's made from his breach. In several senior appellate court decisions in the English jurisdiction, the courts have said that would be too punitive. The Canadians take a tougher line on that. They make you jointly liable for the fiduciary's gains, even if you haven't had a share of them yourself. But the English courts have refused to do that. However, dishonest assistants are jointly liable with the fiduciary to compensate the principal for any loss which has been occasioned by the fiduciary's breach of duty. So depending on whether a loss or gain has been made out of the primary breach, claimants may or may not be able to run a joint liability argument. So that was quite a speedy tour through a lot of very complicated rules. But I am halfway through my lecture and I'm halfway through my time. So congratulations to me. I'm now going to talk about Rowdget, which is the first of the two Supreme Court decisions decided last year, which I'd like to discuss. So the facts of Rowdget. There's a sort of Georgian billionaire who dies, and he leaves a disorganized and hidden estate. What he's done is he's sorted all the money away in lots of different structures in various offshore jurisdictions. And after his death, members of his family aren't quite sure where all the money's gone. So they hire in a company and a firm whose business it is to do asset recovery services. I mean, I just got the wrong job because they charge a large amount of money to people fixing this kind of problem for them. The company and the firm come to an arrangement with the family that they will do kind of forensic investigations and accountancy and try and track through the paperwork and find out where all these assets are. What happens next is that the defendants, who are a director of the company, a partner and an employee of the firm, resign and then subsequently enter into an arrangement with the company without the claimant's consent, under which they're going to provide the services directly and be paid for doing that. That is a breach of the duty of loyalty. They're misappropriating a business opportunity from their principals, and that's a big no-no. In case you're thinking of doing this, you can't get out of liability for breaching your fiduciary duty from resigning your position and then doing the thing which you're not meant to do. That's not a successful strategy. Now, on the facts, if the defendants had sought the claimant's consent, it's found by the judge at first instance that the parties would have agreed a 50-50 profit split. But in fact, the defendants didn't do that. And the claimants, when they subsequently find out what's happened, are not happy about it. And they sued the defendants for an account of profits. At first instance, Mrs. Justice Cockrell makes these findings. The defendants breached their loyalty duty. They made a net profit of £180 million. You see, I am in the wrong job. That's how much you make for doing this. And she says that the defendants have to pay over that sum to the firm and to the company, but she allows them a 25% equitable allowance in recognition of the fact that they did some work in order to make that gain. The case goes to the Court of Appeal. And the defendants argue that the equitable allowance should be uplifted to 50% because the claimants would have agreed to a 50-50 profit split if they'd asked them. The Court of Appeal rejects that argument and they refuse permission to appeal from their finding in relation to that point. So the case then goes to the Supreme Court on a different argument, where the defendants submit that a but-for causation test should be introduced under which fiduciaries are liable to disgorge gains only where they're caused by a breach of the loyalty duty on a but-for basis. Building on that legal argument, if they're successful, their plan is to then argue on the facts that applying a but-for test, either the defendant shouldn't be liable for any gain at all, because if they'd resigned sooner, they could have acquired all the gains without committing any breach of duty, or alternatively, applying the test to the facts, they should be liable only for 50% of the gain, because if they'd sought the claimant's consent, which in fact they didn't do, the parties would have agreed a 50-50 split. And so the defendants would then have made 50% of the profits without any breach of duty. The Supreme Court never gets to 2 and 3 because they reject argument 1. They refuse to change the law in that way and they dismiss the appeal. The majority judgment was given by Lord Briggs. He reaffirms the existing rule that a breaching fiduciary is not allowed to defend his retention of an unauthorized profit for himself by saying he would have made it anyway, even if he'd not committed a breach. There's plenty of authority to support that proposition. I put a couple of citations up on the screen for you. Privy Council decision in Brickenden. The question whether or not the benefit would have been obtained but for the breach has always been treated as irrelevant. Wemby Valley, same thing, Court of Appeal. Lord Briggs is invited by the appellants to change the law in that regard because fairness to honest fiduciaries required an introduction of a but-for causal link between the breach and the gain. And Briggs is, so it's because the appellants are essentially saying that without a but-for rule, fiduciaries can wind up having to disgorge a lot of money in circumstances which are rather unfair to them, as exemplified, for example, by Phipps and Boardman, where the defendant fiduciary was accepted by everybody to have been in good faith, but he was still liable to disgorge everything. Lord Briggs says no, that will dilute the deterrent effect of the no profit rule. And also, if we had this new rule you're arguing for, that would put proof of hypothetical matters into, they would require proof of hypothetical matters which are much more likely to be within the fiduciary's knowledge than the principal's own. So in these disputes, that would be handing an unfair advantage to the fiduciary. Now, there's some important bits of Lord Briggs's analysis which I need to take you through. So at the core of his judgment is a statement by him that the no profit rule is a standalone rule which is distinct from the no conflict rule. I prefigured this in earlier comments. He says there are two separate rules. You've got one rule which says fiduciaries have to avoid conflicts of interest, and you've got another rule which says fiduciaries who make unauthorized gains hold them on constructive trust for their principal automatically. And that just happens by operation of this second standalone rule. And so in order to disgorge unauthorized fiduciary gains are not remedies for breach of the loyalty duty, because liability doesn't rest on a breach of duty. And it follows from that there's no need to prove any causal link between the breach and the gain. Now there are previous cases listed on the screen where the courts have said that causation is irrelevant in cases like this. And instead, the courts have to quantify liability by asking if the defendant's gain falls within the scope of the defendant's duty. It's never really been clear to me what the courts mean by that. That seems to me to be a kind of a conclusion rather than a test. But Lord Briggs didn't just sort of make this up. I mean, there are people before him who have said similar things. But however, it's a rather confusing, because in other parts of Lord Briggs's judgment in this case, he says, well, sometimes causation is relevant. If you use that word in the protean sense of asking whether event A played a causative part in the occurrence of event B. But that's different from common law causation that entails the erection of a but-for type of counterfactual. It says, so there is an element of factual causation which does play a part in the identification of profits for which a fiduciary has a duty to account. But that doesn't mean that causation, even of that non-but-for kind, is a condition for the identification of such profits in every case. So what is Lord Briggs saying? I'm not sure. I've got some questions about his judgment, which I will take you through. So starting with that last comment, he says it's relevant in fiduciary profits cases whether event A played a causative part in the occurrence of event B. I think that equates to a kind of a cause test, which you can see in earlier cases where the courts have also said that in order to differentiate profits which the defendant has to disgorge from profits which the defendant doesn't have to disgorge, the burden of proof is on the defendant to show that the breach had no causative effect whatsoever on the arrival of the money in the defendant's hands. The cases to that effect are on the screen there. Gray and New Algarita Porcupine, for example, as a privy counsel. Lord Briggs seems to think, I think as a result of submissions by counsel, that but-for causation is a kind of common law idea and a cause causation is a kind of equitable idea. That seems to me to be confused and incorrect. You can find plenty of equity cases where but-for causation test has been used. It's used for trustee negligence, Nestle, Court of Appeal decision, trustee breach of duty of due administration, AIB. Meanwhile, over on the common law side, we find a causation used, for example, in Barton and Armstrong, where the Privy Council said that it was possible for in order to have a contract set aside on the grounds for duress to person, the person wishing to have the contract set aside only needed to show that the duress had an effect, not a but-for effect on his entry into the contract. What events are Lord Briggs's test meant to link together? Well, so event B, it must be acquisition of gain. I don't see how event A can be anything apart from a breach of duty. You read his paragraph 36. He thinks the question is, does the profit owe its existence to a significant extent to the application by the fiduciary property, information, or some other advantage which he enjoyed as a result of his position, or from some activity undertaken while he remained the fiduciary which the conflict duty required him to avoid? So that looks to me like a breach of the duty of loyalty. And yet, paragraphs 20, 25, and 47 to 48, he says they're not a remedy for breach of duty to avoid conflicts. So I think that there's a fundamental inconsistency in the things which Lord Briggs is saying at these different parts of his judgment. So, question 5 is Lord Briggs's judgment internally consistent? Well, I just answered that one. The answer is no. It's not. If this rule generating fiduciary liability for gains exists in its own right and doesn't rest on a breach of duty, then causation must be relevant. But if causation is relevant, that must be because liability depends on breach. As the dissenting judges, Lord Leggett and Lord Burroughs, held in their decisions. Does it matter? I mean, am I just making a fuss about nothing? Probably. No, I'm not. Breaching fiduciaries shouldn't have to disgorge everything they own in every case. You know, if I'm a fiduciary and I breach my duty of loyalty to you, you can't get a court order that every single bit of property I have, I now have to give to you. We need to have a rule which quantifies my liability by linking up my breach with the gains that the court wants me to disgorge. If you take the breach plus causation rule, then that is providing you with the necessary link. But if the no profit rule is a standalone rule and liability isn't limited by causation, then you have to quantify it according to some other principle. Perhaps scope of duty, but I'm not sure what that means. If breach plus causation is the right approach, then that suggests that you could use a remoteness of gain test to prevent defendants from being made unfairly liable for too much gain following application of the causation test. And there's a case which illustrates that sort of idea called Warman and Dwyer. It's a decision of the High Court of Australia where the employee of the claimant company misappropriated a business opportunity and started trading on his own account. And the court said, well, we're going to make you disgorge the profits of the first 2 years of trading, but after that, we're not going to make you disgorge anymore. That looks to me like a kind of remoteness cutoff. But if causation is irrelevant, you've got no conceptual space for a rule like that. So you have to do the same work by using a different rule, maybe scope of duty, maybe using the equitable allowance. If breach plus causation is right, then the same analytical structure can be used to decide both gain-based and loss-based claims for breach of the loyalty duty, but it doesn't follow from that the same causation test must apply in each, just that there is one. At paragraphs 59 and 60, Lord Briggs denies that that would be desirable to use the same analytical structure because loss-based claims and gain-based claims are like chalk and cheese. He seems to be talking there about target holdings and AIB, which aren't actually about the loyalty duty. They're about the breach of duty of due administration. If breach plus causation is right, then you can use the same analytical structure to decide gain-based claims against fiduciaries and dishonest assistants. But again, it doesn't follow from that the same causation test must apply to each. There isn't that much authority on what the causation test is for dishonest assistants. who are being sued for gains. But in Noviship, the Court of Appeal says it's not but for, and it should be a real and effective cause test. In Ancient Order of Foresters, the High Court of Australia says the same test applies in both types of case. Okay, Ricadja's done. Now Stevens. Here are the facts of Stevens. Hotel Portfolio 2 owns some hotels and wants to develop them, but it doesn't have the money. So it sells them at a fair market price to Cambulo, which then sells them on to third parties realizing a profit. Cambulo is apparently owned by a man called Stevens, but actually both Cambulo and Stevens are nominees of Mr. Ruhan, who's a director of HP2. And all three of them conceal that fact from the other HP2 directors, shareholders, creditors, because Ruhan is pulling a fast one and he's pushing the properties out to entities controlled by himself in order to make a profit. Stevens gets Cambulo to pay £102 million worth of profit to Ruhan, who then wastes it in a kind of further speculative venture in Dubai. HP2 becomes insolvent, the liquidator sues Ruhan, who also becomes insolvent, and so the last man standing is Stevens, who is being sued for dishonest assistance. So at first instance, Mr. Justice Foxton says, well, the money was held on constructive trust for HP2 from the date of receipt, because that was a gain derived from a breach of the loyalty duty. As constructive trustee, Ruhan owes a duty of due administration that he breached by dissipating the money, dishonestly assisted by Stevens. As constructive trustee of the constructive trust, Ruhan was liable to reconstitute the trust fund, and Stevens was jointly liable with Ruhan to reconstitute the fund, and therefore was ordered to pay all 102 million plus another 60 million of interest. Stevens appeals, as you would too under those circumstances. Notice that he's being held jointly liable to compensate the claimant for that amount. The loss being the loss of the money out of the constructed trust. In the Court of Appeal, though, the court says, well, you have to look at the payment of the money to Ruhan and the dissipation of that money as part of one great big fraudulent scheme under which Ruhan made a gain, but HP2 didn't suffer any overall loss. And the reason for that was that HP2 never had the wherewithal to develop the properties itself. And so it didn't lose anything when it was unable to exploit the opportunity for itself. Ruhan made a gain, but HP2 didn't make a loss. As on that analysis, Stevens wasn't liable for compensation because there was no overall loss, nor was Stevens jointly liable with Ruhan for the amount of Ruhan's gain, because there's this rule, which I told you about already, which says that if you're a dishonest assistant, then under English law, you're not jointly liable with the fiduciary to disgorge the fiduciary's gain. That would be too punitive. So HP2, having won at first instance, I'm very happy about losing at Court of Appeal. So they appeal up to the Supreme Court. It's Lord Briggs again. And he says, well, he goes with Foxton's analysis. He says there were two separate breaches of duty. They were both dishonestly assisted by Stevens. First, the breach of the loyalty duty causes no loss because HP2 couldn't have made a profit for itself. So no compensatory liability for Ruhan and no compensatory liability for Stephen, but the breach did cause a gain to accrue in Ruhan's hands for which he was liable, held on constructive trust for HP2. Stevens isn't liable for that either because the money was gained by Ruhan, not by Stevens. So far, so good for Stevens, but then it all goes wrong for him because the second breach is a breach of the duty of due administration of the constructive trust of the profits from the first breach. Ruhan was liable to constitute that trust fund and Stevens was jointly liable with him. So Stevens loses. That analysis depends on disaggregating two different bits of the facts and saying there were two separate wrongs. And Lord Briggs rejects the submission based on Lord Justice New's analysis in the Court of Appeal that there was just one big wrong. One reason he gave was that a dishonest assistant would be liable for loss in a case where the fiduciary held unauthorized profits on constructive trust for the principal, and the assistant came onto the scene afterwards and helped misapply the funds and thinks, well, if you're going to be liable in that situation, then you should also be liable in this situation. But notice that those weren't actually the facts. That he's saying that his approach is consistent with the facts of another case which could have arisen. Lord Bowes disagrees. He likes Lord Justice Newey. He says you have to treat it all as one big thing and ask yourself whether there's any loss overall, and the answer is no, so there's no liability. He gives various reasons. One at 134 is he draws an analogy with another possible situation which would align with his approach, which again isn't the facts of this actual case, but he also offers a sort of normative reason, which is that once you've, essentially what Lord Bowes says is, once you've decided that you don't want to make dishonest assistants jointly liable with fiduciaries to disgorge the fiduciary's profits, you shouldn't then make them liable for those in this sneaky way by going around and disaggregating it into two liabilities and making them pay compensation, which is exactly the same amount as the profits, which you've decided they shouldn't be liable to disgorge. So that's Lord Bowes' approach. You can't sort of give dishonest assistance with one hand, but then take it back with the other. So a couple of points. The difference between the judges there is turning on the way in which they choose to characterize Rowan's conduct about the breach and the timing of it. And that leads them to take different views of what assistance Stevens provided and when it began and ended. So we're all familiar with the idea that the facts of cases can often be packaged up in different ways. And when the outcome of disputes turns on how that's done, then how do we decide which is the right way of characterizing them? Now, that can turn on normative considerations, as in this case. Each judge identified reasons why his preferred characterization was right. Lord Briggs's approach is quite formalistic. He says, well, there's this formal rule which says that there are constructive trusts of fiduciary profits which arise automatically, and once that's happened, you can't escape from the logic that Stevens should be liable. But he and Lord Bowes are both appealing to considerations of policy. How much liability should dishonest assistants have to bear? You have to make up your own minds which view of that question you prefer. Same general point can be made about other dishonest assistant cases, as often happens that once a breach of duty has been fully implemented, defendants can't be liable for assistance anymore because once the breach is done, it's done, and anything else a defendant might do after that isn't relevant. But when is a breach of duty fully implemented? Well, when it entails the misapplication of funds, courts sometimes hold that a breach isn't fully implemented until the funds have been hidden away somewhere. So it's not just that you've taken them, it's also that you've handed them over to some money laundering guy who will help you hide them somewhere. And the courts in these cases I've listed here have said breach not fully implemented until after that's happened, with the result that the money launderer is liable for assisting. Well, that was rather breathless, but I'm done. Thank you.
Thank you. Thank you very much, Charles, for an extremely illuminating lecture. Thank you so much. I think I would need to go back and update some of my equity teaching materials to make the distinction between due administration and loyalty clearer. Thank you very much. So Charles has kindly agreed to take a few questions. So if you have any questions, please do raise your hands and maybe you can briefly introduce yourself. Yes, Adam. You can press.
Oh, very good. All
Yes,
right.
for the
Very
purpose
good.
of the.
Adam Waldman, University of Sydney. Charles, it seems to me on causation that the difficulty with this is in part the kind of reluctance of courts to just pick what they think is an appropriate test for causation for breach of the duty of loyalty. Because, I mean, certainly in Australian law, but also in the case you spoke of, the court is very keen to say it's not but for causation. And then they're happy to pick apart all of the different ways in which they describe what the sort of causation principle is, but don't kind of give a view on what the right one is if there is one. I guess it seems to me that then in turn leads us to need to try and really pick apart these judgments and make sense of what it is they're trying to say. And so I guess my question is, do you agree with that proposition that courts should just make clear what the appropriate test is, making that choice based on policy? And if so, do you have thoughts on what the best test should be? Because I found that idea of interpreting the decision of Warman and Dwyer of the High Court by reference to remoteness as a very interesting one. Do you think that is an appropriate way of drawing the lines to where we say a breach of fiduciary duty has caused the profits to have been gained?
Adam, thank you for your question, in which you cunningly concealed about 4 questions. So, yes, I agree that there's more than one possible test. Conceptually, there's more than one possible test which courts could use to determine causation questions, across private law. Yes, I agree that it would be desirable for courts to identify reasons for choosing the test which they choose, not just sort of pick one out at random. Of course, I agree. The problem in Rowdget is that Lord Briggs can't make up his mind whether causation is relevant or not, because he wants to say it's. I think the problem with Rowdget is he's trying to deal with submissions by counsel which are founded on a false premise, which the appellants, so the parties start off essentially by agreeing that there is no causation test, and counsel for the defendants is arguing that in order to overcome that problem, the court should look across to common law where things are much more sensibly done, supposedly, and introduce this not just a but-for causation test, but any causation at all. And Lord Briggs, half of his judgment is a response to that argument, which assumes that the premise of the argument is correct, but the other half assumes the opposite, because there are authorities predating the court in which the courts clearly have said that there's a causation rule in play, which isn't but for, it's a cause. Now I think Lord Briggs's impulse is he doesn't want the defendants to get away with it. So his impulse is to just deal with it by saying there is no causation, but he could have got to the same result by saying, well, there is causation already, and it's a cause with the burden on the defendant, and applying that to the facts the defendants are liable. And I think if he'd done that, that would have been more principled. I mean, there's still the question of whether you think but for or a cause would be normatively justifiable in cases of this kind. I think it would, owing to the, many judicial statements, not least by Lord Briggs himself, insisting that it's very important that fiduciaries should be made subject to painful rules which are designed to maximize liability. And that would be the effect of a cause rather than but for. So I think that's how you would justify selecting that. Not sure if oh yeah, remoteness. Your fifth question. So you don't get to remoteness without causation first, right? The point of remoteness is to constrain liability in circumstances where you think that your causation test is producing too much liability, and obviously too much is a kind of normative idea. But both but for and a cause are capable of generating outcomes which can be painful for defendants. You might, in some circumstances, decide that even though you're committed to kind of being mean to fiduciaries, it has to stop somewhere, and say you're going to use remoteness cutoff to achieve that.
Yes, Lucina.
Thanks very much, Charles. And Lucina, just a follow-up question from Adams. I was wondering, what do you think of Lord Leggett's analysis in the Rakase case? Because Lord Leggett was essentially saying, yes, we should adopt a but-for causation test, but the relevant but-for test is just one that negates the breach. And not the test proposed by counsel for the defendant. Do you think that's a plausible approach?
Thank you, Lucina. So if you're using a but-for test, that means that you have to posit a counterfactual. So meaning you look at the facts that they've actually happened, and then you say, let's compare that to the facts of, what would have happened if there hadn't been a breach. And I think Lord Leggett's judgment is interesting because it's showing you that if courts are stuck with a but-for test, or embrace having a but-for test, but then are alarmed because it seems to be producing the wrong result on the facts of some cases, one way out from that dilemma, which is open to them, is to select a different counterfactual from the one which parties have been arguing for, and by cunning selection of a counterfactual which gets you to the result that you want, then you can achieve that. I mean, personally, I wasn't really particularly happy with the way that Lord Leggett sort of analysed what it is exactly that has gone wrong in breach of fiduciary duty cases. And so everyone's going to have to read the judgment in order to understand this, but he's trying to pin it onto use of property and things like that. And so his sort of idea about what the no conflict and no profit rules mean, and where they get traction on the facts of particular cases, I think is it's quite heterodox. I mean, well, Lord Leggett's a very creative thinker. He's not taking the other judges with him on his approach in that regard. Yeah.
Can I just follow up on this? So am I correct that you're not agreeing with Leggett's formulation of the but-for counterfactual, but you're actually more sympathetic with his alternative analysis that gain-based liability should be analyzed as a remedy for breach?
Sorry, are you asking Lucina or are you asking me?
Sorry, yeah, I'm asking you.
I'm delighted for Lucina to answer this difficult question. So, I mean, there's a third way, which is I don't think that the test should be but for.
Yes, so the third way would be the scope of duty, right?
Well, sorry, that's the fourth way.
Oh, then that's the fourth way, yeah.
In my personal view, you know, if I was Lord Mitchell, and I'm sure everybody's very glad I'm not, because although it's easy to criticize judges, it's very difficult to be a judge, and certainly beyond me. I think personally the liability to disgorge profits of a breach of fiduciary duty is a response to breach of the no conflict rule. So I'm disagreeing with Lord Briggs about that. And I think that there should be a causal for liability, that you should satisfy a causal test, explaining how the gain is connected to the breach of that duty. But I think the test shouldn't be but for. I think it should be a cause with the burden on the defendant. And as I said in my lecture, there are already authorities which establish that proposition, which counsel somehow seem to have overlooked. And I think it's a shame that they weren't drawn to the court's attention.
Thank you. David.
Thanks very much. I'm going to stay on the same theme, so apologies for that, but it's very interesting. Doesn't this whole debate that we're engaging in, sorry, David Winterton, University of Hong Kong, doesn't this whole debate demonstrate that the very idea of factual causation is to some extent a misnomer, and that it's really a normative concept, even this idea of factual causation? And I'll try and elaborate what I mean in a couple of ways. So, Charles, you presented the test basically between but for and a cause, and that's generally the contest in tests of factual causation. But one might say, and scientists do say, that what causation means scientifically is that something is necessary for the outcome, which by definition is the but for test. And then, as you showed, you've got a debate between Leggett and perhaps the other justice about what the right counterfactual is. So even that's not clear. But perhaps another way of describing the a cause test is a contribution test, which is what other people would say. So it's really a question of whether something's a contribution, but not necessarily a cause. But we know in the law that sometimes we hold people responsible for things that they don't cause in the sense of the event being necessary for the outcome. It's enough that it just contributes to the outcome, which shows that the whole debate really is about, the question of, and we use causation in the law as a proxy for responsibility always, right? So the real question is normatively what the rule should be for the attribution of responsibility. And usually some sort of causal or contribution test is appropriate for that. But the real question is, what's the right rule for responsibility, which is a normative question, and that you can't separate it from the other, normative scope of liability stuff. I mean, there might be different responsibility attribution reasons, and so in that sense we need to separate it, but the distinction between factual causation and scope of liability is very confusing and misleading, I think.
Thank you. So is that a question or a sort of, yeah?
What do you think about that?
Yeah. Do you agree? Yeah, I do agree. Yeah. So I agree. I think that Lord Hoffman was entirely correct, and he wrote in his famous 2005 Quarterly Review article that causation in law is always chosen by courts for reasons of attribution of responsibility, of liability. The expression factual causation is unfortunate because it encourages people to think that what's being asked is some question about real world events, when that's not what's being asked. I mean, it's relevant only to the extent that if in a real world sense, there's clearly no kind of connection whatsoever between something I do and something which happens around the other side of the world. No one's going to think that I'm going to be liable. But the reason for that still isn't because our sort of intuitions about life and cause and effect aren't engage. You know, we're still making a normative choice there. The language of factual causation makes it look like we're sort of expressing something about the real world. But we're not really. We're saying this is a requirement which could be expressed in different ways, and which one we choose is going to be guided by our ideas about what we think the point of the rules are, which are capable of generating liability. So I think we're on the same page, too. Yeah.
Thank you. Well, I think we've run out of time already, so perhaps may I ask you to join me in thanking Charles for an excellent lecture, and thank you so much for your participation. Thank you.